I know at the AILA National, I know they're already putting together like habeas trainings, but I'm not going to sugarcoat it. I mean, this is federal court practice, and it can be all consuming, and it's on an emergency basis. It's real stuff. It's real
Well, have you
stuff.
heard Ninth Circuits? I read it in Post. I mean, I don't deal with Ninth Circuits directly, but like they're sending out what is it, orders of action or something like that. Have you heard like they're
Yeah,
calling out
there.
people who are
Yes, I have heard about that. Um, because there were a lot of administratively closed cases um, at the Ninth Circuit, their own version of administrative closure, and whether it's being pushed from ICE or the Ninth Circuit, I'm not sure. That a lot of those are being recalendared for argument. It seems that's a weird one because you're in a federal court. They're not in the practice of just letting things like just sit dormant on their docket, and it's federal court post final order of removal because you're a petition for review. So um, but there are interesting things there. I talked to a colleague about this at the Federal Bar Association conference to use the new regulation about administrative closure and when it's appropriate to recalendar, maybe to use that even in the Ninth Circuit recalendaring, even though that regulation has no binding effect on the Ninth Circuit, maybe to use it to say, look, this is the guidance on our opposing party, DHS, about recalendaring, and these factors aren't met here, so we don't think it's appropriate to do it. It's not the best
was there
argument.
something else like order to show cause for it's like a bar ethical thing that's going on again?
Oh, I've seen that too. I've only seen that. I think we probably saw the same post. I don't know.
Yeah,
I can't speak intelligently to that. I will say I don't know the facts of that one.
yeah.
I will say
Well,
I've seen some badly litigated decisions on the podcast. There are attorneys who file petitions for review to get time, and I don't think that's appropriate. I don't think you should be messing in federal court if you're not prepared to make the legitimate arguments, and of course to
no,
meet your opening briefing obligations. But I
I
don't know
agree.
anything about that order to show cause, and I understand. If you're representing your client, sometimes getting them time is what is needed, and that can be a real win. But we're also attorneys with obligations to the court,
Yeah,
so it's a hard one. Again, without knowing anything about these orders to show cause that are being issued, but federal appellate, maybe it's the elitist in me, but federal appellate court is not the tribunal to be participating in half-hearted advocacy and not
yeah,
really making arguments and not complying with the rules.
very true.